And next, continuing in our morning docket, we have a sentencing in People of the State of Michigan versus Brandon McCrum. The advisory guidelines had been scored at 10 to 28 months on a charge of operating while intoxicated third, habitual second. Do you have any scoring challenges?
We do not.
Anything you want to say on behalf of your client? Go ahead.
My client did plead guilty. He didn't put the people to the proofs. He didn't litigate the stop. He didn't litigate the field tests. He acknowledged what he did and accepted the consequences of his conduct. This is important for Michigan's proportionality framework. Under the statements to the pre-sentence investigators are not statements about getting caught. They're statements about the harm he could have caused other people. That is the language of remorse, and it's corroborated by what he has been doing inside the Sheboygan County Jail since October of 2025, which is consistent attendance to Alcoholics Anonymous, consistent attendance to Celebrate Recovery. The court's obviously aware of his record, and it's not a great record. It's a terrible record, in fact, and I'm not going to try to pretend otherwise. He's got a long history of alcohol and drug-related offenses, many involving driving. Just that there needs to be some kind of different approach to these particular types of situations, especially in Mr. McCrum's circumstance. There's been thousands of days of incarceration that he's already participated in. The pattern has continued, not because the prior punishments were insufficient, not because Mr. McCrum is a violent or predatory man, but because the underlying driver of his conduct has never really been adequately treated. The Compass assessment in this case identifies his substance abuse risk as highly probable. Substance abuse disorder that Mr. McCrum has was not developed in adulthood. He developed it as a child in a home shaped by parental alcoholism and chronic conflict between his parents. The environment by itself is documented in the clinical literature as significant adverse childhood experiences that is only part of the picture. When Mr. McCrum was 5 or 6 years old, he was also sexually molested by an older cousin, a teenager, 15, 16 years old, over a period of several months one summer. He began drinking at the age of 8, and by 17 or 18 was drinking heavily. That's not a recreational pattern. That's a child medicating pain he had no language for and no tools to address. Next is that the history of what brought Mr. McCrum to this court is not just advocacy or elocution. It's established science and has been recognized within the federal court system. He is now without resources on the outside, as the court is aware and attached to our memo. His wife, Jennifer, has stood by him for 6 years, married him during his last incarceration. His stepson is in the home and adores him. His wife has identified employment opportunities and treatment providers in Bowling Green, Ohio, approximately 15 minutes from the residence. The home plan is documented in the PSI. The support is real, it is verified, and it is ready to be implemented. He's a very nice man. I mean, it's unfortunate that he stands before the court with a terrible record and type of liability that exists for him. But I'm not making excuses for him. He's pleading guilty. He knows what his liability is. He knows he's going back to prison on the parole violation judge. The recommendation of the PSI is, I believe, 2 years to 5 years. He doesn't get any credit, obviously, because he's on parole. I'd ask you to consider that as well. So thank you for your time.
All right, thank you. Mr. McCrum, you don't have to say anything today, but you are more than welcome to. Is there anything you want to tell me or no?
I was doing very well, and I was a little more proud of myself than I've been in many years. I came to a point in my recovery where I thought I could do it on my own. It ended up being another worst mistake I could have made. And I'm grateful that in all of the decisions I made that I've never physically hurt anybody. No, it's a risk that God is my witness that I'll never take again. Thank you.
All right, thank you, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. On October 16th of 2025 at 2:35 a.m., the defendant was swerving across the center line and the fault line and speeding 60 miles per hour in a 35 mile per hour zone. He had a .146 blood result. He is now 48 years old. He was 19 years old at the time of his first arrest. He is currently on parole for the same OWI third offense. He has a significant criminal history with 15 felonies, 9 misdemeanors, He's been to jail 10 times, prison 9 times, probation 4 times, and 1 time he absconded on parole. A lot of services have already been tried: inpatient, outpatient, AA, NA meetings, MDOC programs. Defendant has exhausted all resources. He continues to make decisions that endanger the community when he is part of the community, and leaves the court as a result with no choice but to remove him from the community and sentence him to the maximum amount of incarceration allowed. Thank you.
Well, thank you, Mr. McCrum. If you please stand for the court sentence. Well, your attorney gave a lot of detailed information, Mr. McCrum, about, your past, and some of the things that have happened in your life have flowed into your life as a result of your choices. Some of them have flowed into your life not as a result of choices of your own, and you've suffered some negative consequences from some of those traumatic experiences. The court knows that full well. I preside over a treatment court program. I'm well aware of the interaction between adverse childhood experiences and childhood trauma and substance abuse and criminality. Yeah, while you were on parole, you went to the Volunteers of America residential program in 2025, a residential treatment program with therapists individually and group therapy. And then you voluntarily left that program, I think, and then that's when you would have absconded parole supervision. So, when treatment's been extended to you, when you abscond and remove yourself from it, that matters. The prosecutor outlined some of your criminal history. It is fairly remarkable. We've got the short prison sentence in 1996 out of Ohio for that attempted abduction. Then in 1999, you get your first DUI in Ohio. So that was, over 27 years ago, you get your first DUI. Couple thefts in Ohio in the early 2000s. 2003, you get a DUI in Ohio, you go to prison. That's your second one. 2005, you have an escape charge or escape conviction out of Ohio. 2007, an OUIL in Ohio. That's your third OUIL. Again, you go to prison. Then you are in Michigan. In 2011, you get your fourth drunk driving conviction out of Sheboygan. You go to prison, looks like for 2 years. In 2003, when you're on parole for that OWI third, this is an important feature. When you're on parole for OWI third, you commit another OWI third. That's your fifth one in Emmett County, and you go to prison for 3 years. After you're paroled, you're back in Ohio. There's some misdemeanors, then a 2019 burglary, and you're back up here in Sheboygan in 2020. We meet, and you're on a OWI third habitual second, which is what you're being sentenced for today as well. It's your sixth OWI conviction, but Michigan caps it at, third or subsequent. And I give you 4 years in prison. You're paroled in October 2024. You abscond that parole in June of 2025. You're caught in July, re-paroled in August of 2025. And by October of 2025, you drunk drive again. This is your seventh one that now I'm sentencing you for while you're on parole for OWI third. So I'm a little confused about when you said you're proud of how well you were doing. I don't know what period you're talking about, because you're on parole for OWI 3, you abscond parole supervision, leave treatment, and catch a new OWI 3 charge while you're on parole for OWI 3. I don't know what period you're talking about where you were doing well, because I don't see anything other than maybe 6-7 month period from the tail end of October 2024 into June of 2025, maybe, if that's what you're talking about. But that's really a remarkable criminal history that shows essentially nonstop criminality, committing crimes while on parole. In fact, committing while on parole the same crime for which you're on parole. Your seventh OWI felony. The guidelines do not adequately take into account the fact that you continue to commit the same crime, and that twice in your life, while on parole for felony repeat drunk driving, you've committed another felony repeat drunk driving. This is the second time you've done it. I gave you 4 years in prison in 2020, and while you're on parole for that, you commit the same offense. I can't see how I possibly give you any less. Should be more. And I think if your lawyer's done a great job by getting you a resolution of at the same level, the habitual second. I can assure you, Mr. McCrum, if I had habitual third or habitual fourth in front of me today, your prison sentence would be long enough it might take your breath away. The maximum that I can do under the Tanner 2/3 rule is a 5-year maximum, increasing the statutory max to 7.5. And I'm going to do that. I think that's certainly called for. It offers an upward departure.
The case before the court was that of the people of the state of Michigan versus Brandon McCrum, who appeared for sentencing on a charge of operating while intoxicated, third offense, habitual second offender. The advisory sentencing guidelines have been scored at 10 to 28 months. The court confirmed at the outset that there were no scoring challenges from either side, and then invited defense counsel to speak on behalf of his client. Defense counsel began by noting several points in McCrum's favor. He highlighted that his client had pleaded guilty without putting the state to the burden of proof, had not litigated the traffic stop, and had not challenged the field sobriety tests. He argued that McCrum had acknowledged what he did and accepted responsibility for his conduct, which he described as significant under Michigan's proportionality framework. He also pointed to statements McCrum had made to the pre-sentence investigator, arguing that these were not the words of someone merely upset about getting caught, but rather reflected genuine remorse about the harm he could have caused to other people. He said this remorse was further supported by McCrum's behavior while inside the county jail since October 2025, where he had consistently attended Alcoholics Anonymous meetings and a Celebrate Recovery program. Defense counsel acknowledged directly and without hesitation that his client had a terrible record, stating he had no intention of pretending otherwise. He noted that McCrum had a long history of alcohol and drug-related offenses, many of which involved driving. However, he argued that the pattern of reoffending had continued not because prior punishments had been insufficient, and not because McCrum was a violent or predatory person, but because the underlying driver's conduct, namely his substance abuse disorder, had never been adequately treated. He noted that McCrum had already spent thousands of days incarcerated, and that continued incarceration alone had not broken the cycle. Counsel then presented background on McCrum's life and history, drawing on a Compass assessment that had identified his substance abuse risk as highly probable. He explained that McCrum's substance abuse disorder did not develop in adulthood, but rather began in childhood, shaped by a home environment defined by parental alcoholism and chronic conflict between his parents. This environment alone, he argued, represented significant adverse childhood experiences as recognized in clinical literature. Beyond the home environment, counsel disclosed that when McCrum was 5 or 6 years old, he had been sexually molested by an older cousin, a teenager of 15 or 16, over a period of several months during one summer. McCrum began drinking at the age of 8, and by the time he was 17 or 18 was drinking heavily. Defense counsel characterized this not as a recreational pattern, but as a child medicating pain for which he had no language and no tools to address. Counsel emphasized that this history was not simply advocacy or allocation on behalf of his client, but reflected established science that had been recognized within the federal court system regarding the connection between adverse childhood experiences, trauma, and substance abuse. He then described McCrum's current support structure, noting that his wife Jennifer had stood by him for 6 years and had married him during his last incarceration. His stepson was in the home and adored him. Jennifer had identified employment opportunities and treatment providers in Bowling Green, Ohio, approximately 15 minutes from their residence. This home plan was documented in the pre-sentence investigation report and, according to counsel, the support was real, verified, and ready to be implemented. He described McCrum as a very nice man and acknowledged it was unfortunate that he stood before the court with such a serious record and level of legal liability. He made clear he was not making excuses, noting that his client was pleading guilty and fully understood he was going back to prison on the parole violation. He noted that the pre-sentence investigation report recommended a sentence of 2 to 5 years, and that McCrum would receive no jail credit because he was on parole. He asked the court to consider all of this in its sentencing decision. The court then gave McCrum the opportunity to speak, making clear he was not required to do so, but was welcome to address the court if he wished. McCrum chose to speak. He said that he had been doing very well, and had felt more proud of himself than he had in many years. However, He said he had reached a point in his recovery where he believed he could manage on his own, and that decision turned out to be one of the worst mistakes he could have made. He expressed gratitude that throughout all of his bad decisions, he had never physically hurt anyone else. He described that as something he would carry as a witness, and said he would never take that for granted again. The court thanked him for his statement. The prosecutor then addressed the court with the details of the offense and McCrum's criminal history. He described the events of October 16th, 2025, at approximately 2:35 in the morning, when McCrum was observed swerving across the center line and the fog line and speeding at 60 miles per hour in a 35 mile per hour zone. His blood alcohol result came back at .146. The prosecutor noted that McCrum was now 48 years old and had been just 19 years old at the time of his first arrest, meaning his criminal history spanned nearly 3 decades.